This is the lecture for Class 3. In your Lawyering Fundamentals class, you are given a package of materials to start your research. This is because you are new to the profession and your professor needs you to start reading legal materials and teaching you how to digest and analyze the law for your written assignments. In real life, and later in your academic career, your research will not be so nicely packaged. In real life, you will be approached by a client or supervising attorney who will give you a set of facts, and you will have to figure out what facts are important and what the law says about your client's situation. To do this effectively, lawyers create research plans. The purpose of a research plan is to keep you organized and calm and make sure your research is thorough. It forces you to ask and answer questions. Research plans also help you be more efficient because if you are true to your plan, you won't forget earlier research efforts, nor will you repeat yourself. Your goal for this week is to develop a generic research plan that you can tweak or adjust to fit your research session. For example, researching an acted law, like a statute, is going to be different than researching a principle of common law that is driven by case law. There are some common elements to our research plans that I'll mention here. Identify the issue. Research plans should treat each legal issue on its own. In your Lawyering Fundamentals class, your professor is trying to teach you how to create issue statements which will organize your legal arguments. Issue statements can also help you define your research. Don't be a cheapskate. Use a research plan for each legal issue. You will also need to know who has authority to speak to the issue. Is it a federal, state, or a municipal issue? You will also want to know if the issue is grounded in statutory, regulatory, or case law doctrine. These preliminary matters will dictate your starting points for research. At first, you may not have the answers to these questions. Ask someone more experienced, or find a secondary authority on point, and spend about 30 minutes getting this background information taken care of. When developing your research plan, it is also a good idea to identify what primary authority is mandatory for your legal issue and what is persuasive. Mandatory authority just means that the legal issues in a jurisdiction must adhere to the law of that jurisdiction. For example, in Hawaii, federal and Hawaii statutes and regulations are mandatory authority. Oregon statutes and regulations are not. Case law is a bit trickier. In a most general sense, federal courts are required to follow judicial decisions from their own court and from any courts to which you can appeal. In this chart, we see which court's decisions are binding on the federal district court in Hawaii. Within case law, only a higher court's decisions are binding on the lower courts within the same jurisdiction. This supports the value of precedent that is a hallmark of common law jurisdictions like the United States. The formal Latin phrase for this is stare decisis. So, for example, the case law from the U.S. District Court for Oregon is not binding on the U.S. District Court of Hawaii because it is out of the court's chain of authority. None of the U.S. District Court opinions are binding on the courts of appeal for their district, though the courts of appeals decisions are binding on all of the U.S. District Courts within their circuit. For example, the Ninth Circuit Court of Appeals are binding on the Hawaii U.S. District Court. Likewise, decisions from other circuit courts of appeal, like the Second Circuit, are not binding on the Ninth Circuit, nor on any of the district courts within the Ninth Circuit. Court opinions from other jurisdictions may be persuasive authority, but the courts are not required to follow their legal analysis or rulings. Persuasive authority refers to the statutes, regulations, case law, and secondary authority that is not controlling in your jurisdiction. Similarly, the court decisions from the Hawaii Supreme Court are binding on all Hawaii courts. The Intermediate Court of Appeals must follow the precedent of the Hawaii Supreme Court, and the state circuit courts must follow the precedent of both the Intermediate and Supreme Courts. Decisions from the high courts of other states, like California, are only persuasive authority. They are not mandatory authority. Likewise, decisions from the federal courts are not binding on Hawaii courts. So even though Hawaii is in the 9th Federal Circuit Court of Appeals, their decisions are not binding on the Hawaii courts who hear state cases. The 9th Circuit Court of Appeals binds only the U.S. Federal District Court in Hawaii. One last note about authority here. Don't forget to note down your citations. Do not get into the bad habit of saying, "Oh, I'll remember that," or "I'll write that down later." Be meticulous. That is what good lawyers are known for. I also want to talk about keywords. It's a common element of all research plans, a list of keywords or descriptors about your legal issue. We started talking about keywords last week. They are the way you are going to search the legal databases and will also be the entry point for the indexes to the materials discussed in last class: treatises, journal articles, encyclopedias, and so on. As you become more familiar with the applicable law, your keyword list will grow and shrink appropriately. Some keywords may work better in indexes, while others work better in databases. For example, if you are researching a contract issue, you might start with phrases like services rendered or breach of contract. But as you start reading your secondary or primary authority, you may learn that the preferred phrase in contract law is failure to perform. You then need to go back to your list of keywords, adjust the list, and which in turn will adjust your research. Every research effort should have a brainstorming session to identify keywords and their synonyms. You can use your word processor's thesaurus to help you generate a list of words, or a legal term thesaurus, like Burton's, which can help you with legal terms. The dictionaries and thesauri in the library are located in the Ready Reference area in the left-hand corner of the lobby. It is important to keep track of your keywords, the ones that work best, and even where they work best, a database on case law or a database of journal articles. It might seem tedious to do this type of documentation, but if you put down your research for a day or a week or even a few hours, you may not remember what keywords you preferred or how you used them, and you'll be happy that you took some notes. I also want to talk about facts, known facts and unknown facts. Start writing down the facts as you learn them. Do not discriminate, as you don't know what facts will be important and which ones will not. They might seem ridiculous at the time, but write them down anyway. You just never know. As you do your research or think about your legal issues, you may identify facts that you need to know in order to analyze the law and apply it for your client. To illustrate with a simple example, if the law on selling marijuana changed this year, and you do not know when your client was charged with the crime of selling an illegal substance, you'll need to track down that date. Facts will always affect how you do your research and what you research. A common tool lawyers use to keep track of facts and dates is a timeline. A timeline notes happenings in the stream of the event from the very first action to the very last. It can note events in days, hours, months, and even years. You can see an example of a timeline for a medical malpractice litigation on your screen. You can simply create a timeline on a notepad with your pen or in your word processor, or you can use graphical programs such as PowerPoint or Time Map for Lexis. Information about these two programs are on your Twin course page under Course Materials. For your homework, you should create a timeline for the assigned problem. You could try your hand using one of these software packages or use your word processor. As you continue to work on a case or a negotiation, the timeline, like the research plan, will change and you'll need to edit it. Your research plan should make sense to you and should help you devise a strategy. There should be a factual analysis, keywords, and sources to consult to obtain an overview of the topic, issue identification, jurisdiction, and the location of primary authority. You should always start by thinking about what your plan should look like. Take your generic research plan and tweak it so that it fits your project. Then put it into action. Begin your research and record it. Look it over, evaluate it, read your research. Do not just collect a bunch of articles and cases and statutes. Decide what you are keeping and what you are getting rid of, and then use that knowledge to revise your plan for round 2 and repeat it. You're going to keep doing that until you reach your goal. How do you know when you've completed your research? When you are sure you have uncovered and connected the authorities. When you keep tripping over the same cases, statutes, regulations, and secondary authority. When you have tied up your loose ends and have a clear and legally sound argument for your client. To help you devise your own research plans, there are some guidelines posted on your course page that outlines what information is critical and an example of what a research plan could look like. The 2 readings noted here are on Course Reserve, and they will also be very helpful if you are having trouble visualizing your research plan. It is very important that your research plans have room to grow and shrink. You will edit them as you do your research, and if you don't, something is wrong. The analysis and research of the law evolves, and so should your research strategy. In summary, organize your facts according to a timeline and start keeping track of what facts you have and what facts you need. Start thinking about the issues to research, the authorities that speak to them, and the appropriate keywords that apply to your situation. And remember to keep adding and deleting words as you conduct your research and learn more about the law. This concludes the lecture for Class 3.